So a waiver is a written document that waives a claim of negligence against an owner, an operator, or an agent of some sort of entity. So there are certain legal concepts that are oftentimes included in waivers, but they exist outside the waiver, notwithstanding the waiver. What I mean is something called, let's say, assumption of risk. If you and I are doing an activity that is inherently dangerous or has inherent obvious risks to it, we don't need a written document to have the person or entity that's in charge protect from the concept of assumption of risk. So assumption of risk is one particular defense to a claim of negligence. A separate defense to the claim of negligence would be a specific waiver, which means I acknowledge that negligence may exist in the future, and as a condition of my participation in this activity, I'm going to go ahead and waive any claim of negligence against the entity or its employees or agents or that sort of thing. The important thing to know about a waiver is you cannot waive intentional tort. So when I say tort, a tort is anything that's not a crime, but it's a wrong from a person to person. Battery, negligence, false imprisonment, all those are subsumed under the concept of torts. You cannot waive a claim for battery or gross negligence, but you can waive negligence. So your listeners understanding the difference between gross negligence and negligence is pretty important because some of these issues come down to that.
Okay, good. We'll break out into negligence as another topic I definitely want to deep dive into.
Okay.
So I'm an academy owner. I've got a waiver. I think I'm covered. Is that a fallacy or?
No, I mean, as long as the waiver is valid, and that's going to be, state to state. You want to have a lawyer licensed in your state to know the specific laws, to know if there's certain things from a policy standpoint or statutory standpoint that you may not be able to, I'll give you an example. Sometimes in waivers, they will have provisions that subject claims to binding arbitration, which arbitration is sort of what they call an alternative dispute resolution. It's very informal. It's like, hey, let's kind of solve this informally without going to court, without doing all that sort of thing. A lot of waivers will have or attempt to have binding arbitration clauses. However, some states prohibit binding arbitration. So it's important to know in your state if your state prohibits binding arbitration. I will say that typically binding arbitration is only prohibited for waivers against doctors and lawyers. Prohibition rarely extends to other occupations, but I wouldn't be surprised in California, a state that is very protective of consumers, very protective of, the little guy, so to speak, that they might have something like that. So just once again, a reason to make sure that you know your state law when drafting those waivers.